Hello, everyone, and welcome to Straight Talking Law. Today's episode is all about planning for the future and specifically why writing your own will could cause more problems than it actually solves, and also the importance of putting powers of attorney in place. Whether you're thinking about safeguarding your family, protecting your assets, or simply making sure your wishes are respected, this conversation is designed to help you understand the risks, the responsibilities, and the peace of mind that comes with getting it right. I'm Jake, and I'm a trainee solicitor in the private client department, and I'm here with Molly and with Michael.
So I'm Molly, and I'm also a trainee solicitor working in the private client department, focusing on wills, lasting powers of attorney, and also probate.
Good, and I'm Michael Horn. I'm a solicitor and director here, and I'm your training principal. So, yeah, that's my role here.
Yeah, glad we got that all established.
Well, yeah, and just it reminds me of all the times we have conversations, and when you take on a trainee and you start working with them straight away, you've got to try and break down the barriers. So you have lots of conversations about quite silly things, really, just to get them to loosen up with you a little bit. And you've both been through that, haven't you?
More than once,
yeah, more than once, over and over. And it's quite important, I think, because when you're speaking to people about their wills, they have to understand, they'll feel in you whether or not you understand what it is that you're talking about.
Yeah, I think it's quite a important and personal topic, will writing. And certainly what we've seen in our experience is just how unprepared people can be to discuss it, because it is a topic that focuses on death and on making arrangements for a time where you're not around, and often people don't like to consider those, and they retreat a little bit back into their shell.
Well, it's a bit frightening, isn't it?
Yeah.
You can see that in the clients when you're sitting with them. Lots of them think it's just a little bit of paper. But when you sit down and you actually say, look, what are you doing about these things? With ladies, you say, what are you doing with your jewellery? Is this something that you've got a memorable piece that perhaps one of your daughters might want? Yeah. And that's really important to save later, after that person has passed away, and somebody in the family saying, well, I thought that was bequeathed to me.
I also think it's a misconception to need to create your will later on in life, which absolutely is not true. You need to get your affairs in order before it's too late, really. And as well with lasting powers of attorney, which we will come on to talk about.
Yeah,
I think that's certainly right. And actually one of the big interests of mine is looking to future-proof wills, which assists, because often a big trade-off is the earlier you put a will in place, the more assets you get that you need to protect in that will. But a big role that we certainly take out, and I know we've all worked on this together, is looking at what clauses we can future-proof.
Yeah, absolutely.
One of the most simple ones is considering the name of a property and where that interest is going, but of course then just putting in the simple clause of, or any other property I own at the time of my passing. And certainly, I know, Molly, we were just discussing this the other day, I don't think there's been a conference we've been in where the clients we've been speaking to have thought they were going to speak about everything they were going to speak about. And actually, we introduced them to numerous more things that they needed to go away and have the weekend to think about.
Yeah, and that just shows how important it is to get legal advice when you're considering creating your will, to avoid missing anything that you'd need to include.
Certainly.
Yeah, and so it's about life planning, not death planning, really, isn't it? You need to be thinking about the assets that you have now, what you might have in the future, how often you need to revisit your will. And you also need to be thinking, if you've recently been divorced, you need to change your will if that's what you want to do, because clearly you're separated from that person. And if you do have an accident or illness, whatever, and you pass away, then that will is still enforced, even though you might be divorced. So it's a whole range of things that need to be discussed. And Molly, your point, which I think is really relevant, about this isn't just about people coming towards the end of their lives. It's about younger people too. And I've had the very unfortunate task of sitting down with people, parents who have lost a child, Regardless of how old that child is. Doesn't matter how old you are, your mum and dad are still your mum and dad. And when they lose a child, they want some questions answered for themselves. Just a very simple one is, do you want to be buried or cremated? And that can bring about a lot of anguish for people. So even if you've got no assets whatsoever, you could prepare a will and just set out your thoughts.
Absolutely. And it's the same with adults that have children under the age of 18. Appointing guardians in wills is really important and overlooked, I think, sometimes.
Yeah, well, we come across that, don't we?
Yeah.
When we've been together and we get wills from these home kits, etc., that you see people get, how bad are they?
Well, pretty bad, yeah.
It's a sort of, we often, sometimes I suspect Molly can hear me sort of almost sigh when I hear that being brought up as that was what was protecting this person.
Yeah.
Up until this point, of course, protecting it, that's quite a generous word. Really, it's more along the lines of just existing as a piece of paper. There's all range of kits, and I see news articles saying, it focuses more on the cost of a will rather than the importance of it, and it'll say why you don't need an expensive will.
Yeah,
but really, the consideration and the time that you should put into this.
But a basic will isn't expensive anyway.
No, certainly not.
So
certainly not.
Go and get one done by a solicitor and get it done correctly, rather than this, let's say, half price will, because your solicitor for a basic will would probably only charge you just a little bit more than what being online, getting one of those online wills.
Absolutely. And the dangers of creating your own will and then in the future, families then disputing it, costs then obviously are astronomical when it comes to that. So spending a tiny bit more, getting the correct legal advice is valuable, really.
We say, don't we, to people that come to us to draft the wills, go and speak with your family. And especially if you're excluding somebody. Because if you're going to exclude somebody from your will, you've got to really be careful about how you're doing that and make some record of it. And so that when you have gone and that person might be expecting a gift from your estate and they don't, you've got to explain fully why they didn't. Otherwise, they will be successful probably in a claim against your estate after you're gone. And the costs for that are paid by the estate.
Yeah.
So you've got to be thinking about these things. So just there's so many things that we could talk about where people go wrong, but let's give some people some guidance on what they ought to do to get it right. Is prepare a list of everything that you own, including any investments that you have, any pensions that you have, so that can be found in the event that you pass away. Make sure that you take that along to your solicitor when you are making your will, and also have a think about what family members you want to leave gifts to and set out fully with full names what they might be, and also who it is that you might not leave gifts to, and set out some reasoning. At our firm, when they come along and they speak to us, we record the meetings. So there's never a question later if somebody challenges the will. There's never a question as to what was said and whether it was clear in their instructions what they wanted to achieve. But I'm going to go back to this point about leaving specific gifts. I don't think it's the case always that everybody is just money grabbing. And of course, there are cases of that. But in the main, people love that person that's about to die or has just died. And they've got memories, they've got things that really mean quite a lot to them. So it's really important that the testator, the person making the will, is quite clear and speaks with the family if they're able to. Is there something that you're expecting to come to you so that can be properly distributed through the estate? And then everybody then only faces the loss of that person rather than feeling upset because they don't think that they got what they were meant to get. So those are big problems. Of course, if you've got a lot in your estate, if you are a wealthy person, then the will take a little bit longer to draft and the costs will go up. And Molly, was it you earlier on that talked about trusts?
Yeah, absolutely. I think trusts can be really important in wills, especially if you potentially have a bit of a broken family. To avoid sideways disinheritance, you can include what's called a life interest trust. And so that ensures that your property, your share of the property, will ultimately be passed to your children, and protect their inheritance. And I think that's really important to note.
Yeah, certainly. I think it's one of the, I would say, invaluable services that solicitors often offer is really this idea of clients explaining what they want in layman's terms, in simple terms. And we are the ones who go and find the clauses, the trust elements, the mechanics to get that in place.
Yeah, when you're considering these things, you've got to as well think about who the executors are. Because if you are saying, okay, I want this in trust for that person or those group of people, then you've got to think about how that trust is going to come about. And I have this conversation with people, and that they want their mate or their brother or sister to be the executor or one of the executors, and then they would be the trustee. And it may be, if we're talking about people who are elderly coming to the end of their lives and they're selecting somebody who's of the same age,
Well, yeah.
then they're in a position that they may be appointing somebody as an executor who may well pass away before them or may not be capable of delivering the administration of the estate. So you've always got to have a think about who the executors are and try and pick those that you think might outlive you, because that's the purpose of the executor, is to deal with everything once you're gone. Yeah. So that's wills. Just a little bit of a checklist for wills. Try and avoid doing the online ones. Get some advice. Get a list of everything that you own, including the details, the account numbers, etc. Go along, see your solicitor, and just take your time to explain everything that you've got and what you want to achieve. Don't go cheap. They're not expensive, but don't go cheap. Go for the solicitor that can do the job. And then you'll learn a lot more about your estate than you thought. And then be thinking carefully about your gifts, your family members, and think carefully about who the executors are. And that kind of is a bit of a rule of thumb on what to look for in the person that you're drafting your will with. Just finally on that point, keep a copy of your will at home and keep the original will with your solicitor. That might be a good idea. So let's talk about something else that's really necessary in people's lifetimes. What might that be?
Lasting
LPAs.
powers of attorney.
Yeah. So they're called lasting powers of attorney, but we abbreviate them to
LPAs.
LPAs. Yeah. And how many LPAs should somebody be thinking about?
There are two types of lasting power of attorney, LPAs. So you have health and welfare, and property and financial affairs. And it's important to note they are completely separate documents, not to be confused by each other.
Yeah, it's interesting because everyone believes they go hand in hand, these two documents, but they are indeed entirely separate. And it's very important to understand there is a way in which the LPAs need to be prepared, which on the face of it isn't always too understandable. The documents themselves are weighty. They're around 20, 30 pages each. And what is important to consider when it comes to LPAs is, quite similarly to wills, firstly, who do you want your attorneys to be? Now, your attorneys are the people who are going to be making decisions to assist you. There's a common understanding that when an LPA is put in place, you lose any immediate right to make your own decisions. That's not true. There are mechanics in LPAs that allow you to leave them almost dormant until a time where you need assistance. You register the LPAs or request that they're registered right away. And so your attorneys can step in at any time. But ultimately, we suggest get your LPAs in place as soon as possible, because you never know what might happen.
And that doesn't mean that your attorneys have to act straight away. They can assist you. But we like to talk about capacity and when LPAs will be necessarily used by the attorneys. So Michael always likes to give an example of the raincoat, and whether it's stormy outside and I want to go for a walk. It's raining, it's dark, it's cold. You can't stop me from going for a walk, but you might suggest that I put my raincoat on. Isn't that right, Michael?
Yeah, that's absolutely right. So what you're both talking about is, does this sliding scale of assistance that the attorneys have to give the donor, the person that signed the power over to the attorneys, and the attorneys always have to act in the best interests of the donor. So if you're granting this power to somebody, you can rest assured that they must always act in your best interests. And that raincoat scenario is, if somebody likes to walk in the park at 3 o'clock every day, that's what they do. And that's what they want to do every day. And one day they say, I want to walk in the park, but it's raining and it's horrible and it's cold. Then you'd expect the attorney to say, well, that's fine, mum, dad, cousin, brother, friend, whomever it might be. You need to walk in the park. It's good for you. But what also is good for you is that you must put your coat on and stay dry and warm. And that's the level that you want the attorney to interact with you at. And if they're stuck and they're not quite sure what their duties and roles are, it's explained to them, of course, fully when they're signing up. You have to do that. It's in the power of attorney application. But where can they find some direction for that, Jake?
Well, there's two places that we recommend going first. The first is just the government website, nice and simple. You can type in LPA, lasting power of attorney, and find everything you need. But also within each application itself, there is the guidance in section 8. That's actually a requirement that everyone who's going to be signing the document needs to have read and understood. That's both the donor and the attorneys. And what that sets out, as we've discussed, is that ultimately you need to be honest, you need to be understanding that you're going to be acting in the donor's best interests. And that can be taken one step further by the involvement of instructions and preferences. Without this, there is a very basic understanding that you need to act in the donor's best interests. But donors, if they are a bit worried that there are certain circumstances that may arise, whether it's with their medication or perhaps with a particularly difficult share portfolio that they know that their attorneys aren't going to maybe always be able to handle, they can leave instructions and preferences to assist.
Yeah. And we call that a letter of wishes, don't we? So it's always, even with your will, it's useful to set out a letter of wishes for those that are now doing the thinking for you to follow. So that's very useful, isn't it?
Certainly is. And those can be recorded in the actual documents themselves, the LPA documents themselves. The difference, though, between those is that a preference is something that the attorney should be minded of. And instructions are quite simply that, instructions that the attorneys need to follow.
Yeah. Jolly good with all of that. And people get a bit, I don't want to fill that in, it looks complicated. But it's really, really important set of documents.
It is. And especially as we were talking about wills, important to instruct a solicitor. Well, with LPAs, it's equally as important because you have what's called a certificate provider who confirms that the donor actually has capacity at the time of signing the document. By appointing a solicitor to act as a certificate provider, especially here at Kidwells, as we said, we record all of our client meetings. You have that proof that at the time of signing that document, you had capacity, and the possibility of it being contested reduces.
Let's have a chat about capacity then. So what does capacity mean, Molly?
So capacity means whether you have the ability to make your own decisions, as we spoke about decisions, whether you need to put your raincoat on when you go outside. It may get to a point potentially where you're actually not able to make that decision yourself for any reason. And the misconception is that these documents need to be put in place later on in life, when really you could tomorrow have an accident, have a brain injury, and won't be able to make decisions for yourself. So it's really important to have them in place.
So the golden rule is LPAs and wills done before capacity leaves you,
Absolutely.
either by accident or illness or old age.
Yeah.
So get them done nice and early is the answer.
Yeah.
What kind of, Jake, what kind of questions do we ask people when we're asking them about capacity?
It's interesting because whenever we say to clients, okay, we're going to test your capacity, you see a look of almost fear on their face, because it sounds like such an awful question to ask. But actually what a test for capacity might be is simply recalling a little bit of long and short term memory. It might be, for example, where the person grew up, who's in the room, what they had for lunch, those sorts of questions. Although they're simple, they're surprisingly informative, and they give you a lot of an understanding about how the person is you're speaking to.
And we do that without telling them, don't we?
Yeah.
So we come in and we're having a nice relaxed chat. How you doing? Where did you work? You're married to? How many children, or what do they do? Why are you here today? And then you can assess whether or not people are really with capacity. And if they're not, if you've got some doubts about it, then you don't progress.
And that's where it's difficult, because you then have what's called the court of protection and deputyship, and that is such a lengthy and costly process. So having lasting powers of attorney in place really safeguards you and protects you in your lifetime.
So what you're saying is that once you lose capacity, then the only way that people can take control of your assets is through the court of protection.
Exactly.
Yeah, and it can be lengthy, but it's most definitely expensive.
Yeah.
Considerably more efficient to get it done beforehand.
Absolutely.
Good. So I think one thing that we need to go back to is about social media and passwords, because I hear quite a lot about parents saying, I lost whomever it is, whatever the person's name might be, and I can't get on his social media.
Yeah.
I can't see what he was doing. I can't see who he was speaking to. I don't understand why he did those things. So it's very relevant, I think, that as a young person, you might want to, in some way, leave passwords.
Yeah.
And just so that a trusted person can access your account. And that may be that if you're doing your will, you appoint, say, I don't know, the solicitors as the executor, where you can say, look, I'm leaving you my passwords to my Facebook and my social media, etc., to use at your discretion if my parents become distressed that they don't know things. I love doing these podcasts. I love working with the younger lawyers in the building and seeing you all progress, seeing you advance. You're clever people, there's no doubt about that. You wouldn't be lawyers if you weren't. And a great pleasure of mine personally is seeing you advance and seeing your skills being really honed and sharpened. And it's a pleasure. Genuinely, it's a pleasure to work with you. And I like you both. You're great. And I have to mark your work. So I'm constantly going through what you're doing. And I do read your emails, Molly, don't I?
Yeah.
and I read through all the documents. And so I know that you're good lawyers. You come to me with any queries. You come to me with anything that you need to ask questions about. Your drafting and your legal work is brilliant. Both of you, perfect. But really, for me, the test, you are lawyers. You're expected to be able to do that work well. Other lawyers don't, I know, but ours do. But for me, the measurement of what you're doing is the feedback that we get from clients. And the feedback that you both get from people, clients that are working with you, is that they love you, is that you're great, you care, and you're doing a good job, and they go away from here and they feel secure. So doing the job properly is about getting the law right, getting all the information out of the clients so that their families don't suffer, either when they lose capacity or when they pass away, and to deliver that package so that that client feels safe. And I've got to say that in the feedback that I see and what I hear, because I also listen to the recordings when you're seeing people, and I think you're doing an excellent job. Your clients love you, and there's a reason for that. It's because you're really very good indeed at what you do. And genuinely, I want to thank you for working here and choosing to work with me. I'm lucky to have you. Thank you for being on the team, both of you.
Thanks, Michael.
Thank you.
So that's it for this episode of Straight Talking Law. We've explored why writing your own will can lead to serious complications and why having lasting powers of attorney in place is such an important step in protecting yourself and your loved ones. If you'd like advice or want to discuss your own situation, please get in touch with us on 01432 278 179. Thank you for listening, and we'll see you next time.
Bye, everybody.
Thank you.